Number two, I kind of think we talked about it already, guardianship and advanced care directives. So a guardian is a person who's in charge of you. They can make decisions. They can, sign contracts. They can control who you see. They can control which one of your 3 kids you see. It could be one of your 3 kids. It could be the bad kid in that example before. Imagine that. Imagine how the bad kid can turn into an angel all of a sudden in the courtroom, and they could be appointed because it's more convenient.
In terms of guardianship, at what point, because obviously if someone's incapacitated, let's say to the point that they're in a coma, clearly a guardian needs to come in. But let's say the person is alive, they talk, maybe there's some issues. Who determines that the guardian is allowed to step in and start making decisions for that person?
So it's a process. You have to go and you have to do a petition. You have to be evaluated by multiple doctors, and then there's like a laundry list of powers and rights that you either keep or lose, and the guardian gets has the ones that you can't, the ones you lose. And so at that point, once there's a guardianship appointed, there's a court order. And just like in probate, you waive the court order and, people listen because they have to. There's a legal obligation. This person has control. So in lieu of a guardian, and guardianship, does have its benefits in certain circumstances. But in lieu of a guardian, you can do your advanced care directives. You can do it a power of attorney, a healthcare surrogate, and a living will. And it's like a substitute. Just like a trust is a substitute for probate, advanced care directives are a substitute for guardianship. And so advanced care directives are very commonly, part of a basic estate plan. You see them all the time, right?
Yeah, you mentioned a few of them. And not only do I see them all the time, I encourage every one of my clients to get them. But you mentioned a few there, the power of attorney, living will, healthcare surrogate. We're going to briefly touch upon what each of those are to kind of give everyone a little bit better understanding.
Yeah. So power of attorney appoints a person called your agent. It used to be called an attorney in fact, but now it's called an agent. Either way, it's a person or a business, a company, professional, to act on your behalf, as if they're you and for your benefit. They have a fiduciary duty. I mentioned that word before in the context of an executor or personal representative. That just means that they have an elevated standard of care to put your needs ahead of their own. Or they can be held liable for either not doing that or being negligent, to not do that. It's an elevated standard of care. And so this person has power over things like financials, banking, insurance, legal, taxes. I always say Comcast in my meetings because I try to, lighten it up because it's a deep, dark subject. Nobody laughs at that though, so I really do appreciate that you're laughing. Try calling Comcast and seeing if they'll talk to you without validating them. Really getting, things done for someone else requires this type of document. One judge who will remain nameless in Broward County referred to them as weapons of mass destruction because, as you can expect, going back to, good kid, bad kid, and medium kid, in the wrong hands, they could be quite devastating and destructive because third parties really do have to rely on them. They have to honor them. There's exceptions, but that's kind of the rule.
Let's assume that someone has 2 good kids. Can they have...
Doesn't happen.
Very true. But can they have and this is a question for the audience, can they have power of attorneys, or does it have to be a decision on one of them?
Oh, that's a good question. So yeah, you can do you can do 3, and it's majority. You can do and then they each have the ability to act independently by default. You can change that in the document if you want. I would say that, we give a lot of practical advice when it comes to these documents because some institutions are very fickle about how they interpret them and work with them. There could be problems with how people do it instinctively. And so we do provide some value there, but yeah, you can do that. the healthcare surrogate is like a medical power of attorney. It really allows you to participate and make decisions on behalf of someone else, as their surrogate. Typically it's for, like, if you're unconscious, like you mentioned, you're unconscious and you can't communicate, you can't decide what treatment to take up in your case, someone else is going to have to make the decision. And you can either decide, as I mentioned earlier, or the court will decide for you. In a case of a surrogate, the law changed relatively recently, and I think a favorable way, because it allows you now to appoint somebody who has the ability to participate now, while you do have capacity, but you're still in control of yourself. You're still in control of your decisions. They could just be involved. I think that's very beneficial. And of course, they have access to records.
Like one for you then, for people that had healthcare surrogates created, for anyone who's listening who maybe has done some estate planning, do they need to get them amended to reflect the law change?
No, you don't have to. Just like a power of attorney and just like a will, wills that are outdated or from other states, you really don't have to get them done again, but you should, because you should. I've seen a lot of problems probating out of state wills. Even though they were valid, the courts still are a pain in the ass. The surrogate, though, does not need to be redone, but you should redo it because the laws change, So the living will doesn't appoint anybody, though I've seen them appoint people. Living will is think about Terry Shiloh in like the 90s. Her husband and family fought over whether to keep her on a machine because she was in a persistent vegetative state. For 4 years they fought. God knows how much money they spent. But ultimately the husband, won, and they pulled the plug. She could have avoided all that with like a 2-page doc that said, I do not want to be kept alive on a machine in the event of I'm in a persistent vegetative state, I have a terminal illness or end-stage condition, and two doctors say that there's no reasonable likelihood of recovery. Only then do they take you off the machine. It's not like you go and you're stubbing your toe, So it's those 3 documents that are relatively simple but significant impact in people's lives during life. When you pass away, they immediately become just useless pieces of paper. So yeah, I answered that question pretty well, right? You're happy with that?
Absolutely.
Haimo, Haimo.